Welcome, Queenslanders suffering from a workplace injury. My name is Alexander Gunning, and today we embark upon a journey to unveil the true cost this burden has upon our community. Our quest today seeks to answer a pivotal question. How well does the law stand by those who sustain an injury in the course of their employment? Consider this: the factory worker whose repetitive motions lead to chronic wrist pain, or the nurse whose heavy lifting results in a debilitating back injury. These are not isolated incidences. They represent a pervasive problem affecting workers across various industries and occupations. The statistics are alarming. From 2019 to 2020, there were a total of 28,732 Queenslanders that suffered a serious workplace injury, and 194 deaths that were a result of a workplace injury. Beyond the statistics, there are the untold stories of Queenslanders whose lives have been irrevocably altered by workplace injuries. The chronic pain, the loss of mobility, the inability to engage in once cherished activities, and the financial strain. These are the silent burdens borne by injured workers and their families. This presentation will illuminate to you the shortcomings of the current legal framework in Queensland, particularly its failure to adequately protect and compensate those who experience significant workplace injuries. We will explore the complexities of both the no-fault workers' compensation system and the fault system, revealing how these avenues often leave seriously injured workers without the means to sustain themselves, forcing them to rely on inadequate government assistance and ultimately shifting the cost to the taxpayer. Finally, we will propose potential reforms that could alleviate these shortcomings and the burdens they place upon the community. In Queensland, if a worker suffers an injury at work, generally they will be covered under the Workers' Compensation and Rehabilitation Act 2003 Queensland, which we will refer to as the WCRA. The WCRA provides a hybrid system for an injured worker in which they may access either a no-fault scheme or a fault scheme. To be eligible to receive compensation under the Act for the no-fault scheme or fault scheme, a person must meet the following definitions under the WCRA. That is, a worker suffer a personal injury in the course of their employment, and the incident has to be a significant contributing factor to the injury. For example, if a person has a pre-existing injury, the workplace injury must be a significant contributing factor to worsen the initial injury, and compensation will only be given for the aggravation. Importantly to note that not all injuries sustained in the course of employment will meet the definition of injury under the WCRA. Injury does not include a psychiatric or psychological disorder arising out of or in the course of employment, under a number of circumstances. Injured workers and their dependents who meet these definitions are eligible for compensation under the WCRA, although not everybody meets the definition of a worker. Once an application for compensation has been lodged and accepted by the insurer provides a critical safety net for those who are seriously injured at work and are able to recover from that injury and return to work. This safety net includes the insurer covering medical costs, rehabilitation costs, engaging in a return to work program, and providing a subsidized wage. Meeting these definitions and receiving compensation at times can prove challenging. For example, in the case of PB and WorkCover Queensland, although this case was in regards to WorkCover breaching PB's privacy rights, the facts of the case involved an injured worker who was exposed to chemicals on his skin in which he sustained a medical condition known as bilateral contact dermatitis. PB made a claim for compensation to WorkCover, the insurer. Although PB did everything correctly and met the criteria to be covered under the WCRA, due to WorkCover inaccurately taking details of the incident and a number of further errors throughout the claim process made by WorkCover, PB's claim was rejected. And in the case of Goodhue and WorkCover Queensland, Goodhue had made a claim for compensation, which WorkCover at first accepted and later rejected because they believed he did not meet the definition of worker under the WCRA. Through the court process, it was found that Goodhue did in fact meet the definition of worker and was covered under the WCRA, and was able to continue with the claim for compensation, although he faced further difficulties with his claim at the fault of the insurer. These cases show just some of the difficulties an injured worker may face when trying to obtain compensation for the injuries. For those who suffer a degree of permanent impairment, or DPI, as a result of a workplace injury, in addition to the prior mentioned forms of compensation, an injured worker will also be eligible for compensation for the total DPI from the injury. The amount that will be offered to the injured worker will be determined from the worker's overall percentage of DPI. and calculated as that percentage to the maximum payable amount under the WCRA. Importantly to note, this index does not allow for pain and suffering to be included in the assessment of impairment. When a worker is unsuccessful for a claim of compensation under the WCRA, there are avenues for appeal. However, these are generally complex matters that require solicitors and can be quite expensive and time-consuming. If a worker does engage legal representation and is successful in the appeal, legal fees are not reimbursed by the insurer and the injured worker is left to foot the bill themselves. Generally, this cost will come out of the overall amount the injured worker receives from either a lump sum payment, settlement, or their damages, and legal fees have been capped at a maximum of 50% of the claim. In the time the injured worker is appealing the claim, they generally have no source of income because they are unable to access any forms of income as they cannot work, and have no assistance in their rehabilitation except for that of the public system, such as Centrelink and the Public Health Service. Even accessing these means of assistance can at times be challenging, and if they are successful, these public health services offer inadequate support and puts a further strain on the public health system, costing taxpayers. If a workplace injury resulted from the employer's negligence, an action in negligence may be possible under the WCRA. If the worker's DPI is below 20%, then once the injury is considered stable and compensation has finished for the injury, the worker may elect to pursue either a lump sum settlement or an action of negligence. They cannot pursue both. However, if the DPI is 20% or above, the worker may take a lump sum payment and still pursue an action in negligence under the WCRA. Generally in Queensland, an action of negligence is governed by the Civil Liability Act 2003 Queensland, or otherwise known as the CLA. The CLA states that workplace injury issues are dealt with by the WCRA. For a worker to be successful in an action of negligence under the WCRA, the following elements must be established. First, the injured party must show there was a duty of care owed. In the case of an employee and employer relationship, generally there is an established duty of care owed under the common law to take reasonable care in the circumstances to avoid foreseeable injury to an employee. This can include a duty to provide a safe system of work and provide a safe place of work, a duty to hire and train competent staff, and a duty to provide proper plant equipment. However, there are limitations to the scope of the duties an employer may owe, such as where it is not reasonably foreseeable that a worker could suffer an injury by carrying out the job the worker had agreed to do under their employment contract. Second, it must be shown that there was a breach of the duty of care owed. In some cases, an employer may be vicariously liable for the actions of another employee. This may be an avenue to show that there has been a breach of duty by the employer for the actions of their employee. Liability for workers in some cases may be delegated, and other issues of liability are non-delegable, meaning the employer cannot escape liability for certain acts or omissions. To establish a breach of duty, the injured worker must show that an act or omission by the employer has breached the duty of care. To do this, the common law principles apply. That is, if the risk was foreseeable, not far-fetched or fanciful, and in the circumstances a reasonable person would have taken precautions and the employer has failed to take those precautions, there will be a breach of the duty of care owed. Third, it must be established that the breach has caused the damage or injury. That is, it must be shown that damage has been caused by the breach of the duty of care owed, which in cases as these will be achieved by the degree of total impairment the worker has received from the injury. To do this, the but-for test is applied. That is, one must ask, but for the actions of the employer, would the harm have occurred? However, the but-for test may not always have an answer for where there are multiple causes for the injury. In these cases, the courts may look to see if the conduct materially increased the harm suffered. Moreover, The question must be asked if the remoteness of the harm suffered is too great or too far outside the scope for the employer to be held liable. The onus of proving that there was a breach and that breach caused the harm lay with the injured worker and must be proved on the balance of probabilities. Once these criteria have been met, an injured worker will have an established claim for negligence under the WCRA against the employer. The injured worker will be entitled to damages for the damage they suffered. However, damages have been capped and limited. Additionally, the employer may have a number of defenses that may limit or totally exclude their liability, such as certain types of contributory negligence by the worker. If the worker is found to be liable for contributory negligence, depending on the type of contributory negligence, there will be a reduction to the overall damages, or the claim may be defeated entirely. This could include a failure to take account of an obvious risk or intoxication by the employee. To identify the risk of harm, it must be determined what person, thing, or set of circumstances gave potential for the harm. Additionally, if an amount is awarded in damages or a settlement is reached, the insurer has the first right of claim to the amount awarded in damages to recover their costs for the compensation claim. Additionally, other costs may be taken out of the overall compensation received by the worker, such as specialist medical reports, which can range in the thousands per report, Medicare expenses for the work covers related treatment, and more. Additionally, there are further limitations that have been placed upon an action of negligence, that is, trial by jury. Although there are exceptional cases where it may be argued that a matter should be heard by a jury, this generally does not happen. We should be exploring alternative compensation schemes, such as the no-fault system for medical injuries implemented in New Zealand. All workplace injuries are covered regardless of fault, providing faster and more certain access to compensation for injured workers. While such a system has its own complexities, it offers a potential model for reform that could address some of the shortcomings of the current legal system in Queensland. The New Zealand system has been praised for its efficiency, simplicity, and focus on the needs of the person. However, it has also been criticised for potentially limiting compensation for severely injured workers and removing the deterrent effects of negligent claims on employer behaviour. A careful analysis of New Zealand's model, including its strengths and weaknesses, could inform potential reforms in Queensland that would ensure the worker is not left behind. As we have seen, those currently left behind are those who do not meet the definition of a worker, injury, or a significant contributing factor to the injury under the WCRA and are left with no real means of support. Additionally, the New Zealand no-fault model, with its emphasis on community, responsibility, comprehensive entitlement, and rehabilitation, aligns most closely with the principles of distributive justice. Distributive justice focuses on the fair allocation of resources and burdens across society. In the context of accident compensation, it suggests that the cost of accidents should be distributed in the way that benefits society as a whole rather than focusing solely on the individual fault or blame. The New Zealand scheme embodies this principle by providing compensation and rehabilitation to all injured individuals regardless of fault, and by funding the scheme through broad-based levies. While elements of other tort theories may also be present in the New Zealand-based model, distributive justice is the most prominent and foundational principle underpinning its design and operation. In conclusion, the number of Queenslanders suffering from workplace injuries demands our attention and action. The current system, while providing some support, leaves too many individuals struggling to rebuild their lives. It's time for reform. It's time to create a system that truly upholds the principles of justice, fairness, and compassion. It's time for Queenslanders to stand by its workers, ensuring that they receive the support and compensation they deserve when injured in the course of their employment. Thank you for listening.